Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss part 8 of the Code of Civil Procedure. This part talks about reference, review, and revision. In this video, we are going to discuss reference, which is given in section 113 of the Code of Civil Procedure 1908. Reference, review, and revisions are the remedies provided to petitioner to make their claims in front of a higher authority or the similar authority for reconsideration of their case, or for asking the court to reconsider their case or to make a new assessment if they feel that they are aggrieved or some higher authority is needed there to decide the matter. So, in this video, we are going to talk about reference. Reference is mentioned in section 113 of the code, and what are its conditions, how it works, how it is preceded, what happens when a reference case is preceded. It is being discussed in Order 46 of the code. Moving on to section 113 of the code, it says reference to the High Court subject to such conditions and limitations which may be prescribed. Therefore, at any time what conditions and limitations are prescribed, the reference is subjected to such conditions, and only High Court has the authority to take the reference cases. So the Bail Act reads, any court may state a case and refer the same for the opinion of the High Court, and the High Court may make such order thereon as it thinks fit. So the sections mainly talk about when any subordinate court or any lower court wants the opinion of High Court, it may refer the case to the court, and it is on the discretion of the court whether of the High Court whether it will take up the matter for reference or whether it will not, provided the proviso here says that if the question is such a question which includes a question of validity of any act, ordinance, or regulation, or any provision contained in some act, ordinance, or regulation, or any legislative principle, then High Court shall decide upon the matter. It does not have the discretion, and it is mandatory for the High Court to give its reference and not just return it back. So this is what 113 says. So it can be seen that the matter is still going on in subordinate court. Let's say that A has filed a suit which involves the reference of High Court, and the suit has been filed in district court. So the district court will refer the case to High Court for its intervention in the decision. While the case is still pending, the case has not been decided yet, and it is moved forward to High Court for the reference. The case must be non-appealable, that it should not be appealed. The decree issued shall not be appealable, and there must be a confusion or there must be a matter of doubt. Moving on to the Order 46, which talks about the condition of references in this Code of Civil Procedure. There are several rules that lay out certain mandatory conditions and procedures for this portion. As we have seen that lower courts or subordinate court or the court where the matter is being proceeded, they will approach High Court for the reference. So only High Court has the authority to hear for the reference cases. Now, lower court may ask the High Court for reference in two conditions: either by suo moto, it can take the suo moto cognizance of the matter in issue of the confusion, or when the parties to the suit are applying for the reference of High Court. In both cases, subordinate court may apply to High Court for its reference. Now, the suit must be of such kind where its decree is not subjected to appeal, or where the execution of any such decree is pending and there is a question of law or usage having force at that time arises. Such cases may proceed for reference in High Court. The subordinate court must draw a statement of facts of the case and the point on which the doubt is entertained, and only such reference point, such doubtful point, in the opinion of the subordinate court, must be put forward before the High Court. Now, Rule 2 says that the subordinate court may pass decree contingent upon decision of the High Court. So the subordinate court may stay the proceeding, proceed with the case notwithstanding such reference, or may pass a decree in accordance with the decision of the High Court that has been made in reference, provided that High Court must provide a copy of such judgment to the subordinate court. Before that judgment, no decree shall be executed. The High Court, when it hears both the parties and make a decision in reference case, must transmit a copy of judgment to the subordinate court under its sign, and the subordinate court must give its decision and dispose of the case in conformity with the decision of the High Court. This is stated in Rule 3 of the Order 46. Now, the High Court has its own discretion to entertain the matter, the reference point. It may reject the reference if it does not involve a question on legislation. But if there is a question on legislation, it becomes mandatory for the High Court to take such matter into its cognizance and decide and give reference on it. So this was all for reference. I hope I made it very clear for you. Please feel free to contact us at legaldarshan@gmail.com if you have any queries, doubts, suggestions, and feedbacks. Also, if you like this video, please like, share, and subscribe to our YouTube channel. Thank you so much for watching. Have a good day.